My name is Ronnie Conway. I'm the principal lawyer and solicitor advocate at the Conway Accident Law Practice, and I'm grateful to be given the opportunity to be saying a few words about accidents in the workplace. Can I first of all say that I have witnessed a revolution in these kinds of accidents since I started off in my legal career as a young man. And a lot of that comes down to one simple law which emanates from the European Union. We all hear about these daft laws that come from the European Union about safety and regulatory standards. From my perspective, there was a simple legislative change in 1992 which required all companies and firms to proceed by way of risk assessment. It's not a difficult concept. It just means thinking in advance about the kind of hazards and possible problems that might occur at work and taking steps by way of reduction of risk to the lowest level reasonably practicable. And the effect of that has been dramatic. The accident figures, if you look at the accident figures before 1992, they are now down by around 75%. And every time I hear people talk about European legislation and how pedantic and busybody and difficult it is, I think this is not opinion. Look at the figures. This is arithmetic. This law has worked. When I was a young man, I started off working in Lanarkshire, which is a typical mining and factory area. And the kind of accidents that I saw were, insofar as the factories were concerned, the whole workforce was deafened because of noise. And it was commonplace for people to have lost limbs or fingers by coming into contact with machinery. Now, thankfully, most of those kinds of accidents have gone. I always used to laugh. The miners in particular were men who I would have, when I think back in retrospect, these guys were younger than I am just now, but they were completely worn out. Their job had worn them out completely. Coal dust in particular was a killer. The miners used to claim, they used to say to me, ironically, that the local medical profession would never prescribe the condition of pneumoconiosis, which is a typical condition caused by exposure to, in particular, coal dust, because none of the doctors knew how to spell it. Now, thankfully, those old days are gone. And the kind of accidents that I see now are moving and handling accidents, where people are asked to lift weights that are excessive, falls from height, and trips and slips in the workplace. Now, all of these are easy to stop, but and if the company pays attention and carries out a proper risk assessment and treats the risk assessment as a blueprint for action, there is no reason to there is no reason that these accidents should be continuing. Unless, of course, the accident victim has been spectacularly stupid, and frequently that's what the insurers want to say to me when I'm representing them. But in fact, in my experience, what happens is that people simply want to get on with the job, get the job done, job which they haven't been given proper instructions on, jobs where they haven't been trained properly, and jobs where they don't have the proper protective equipment. And in that situation, the insurance company are on the line. Let me say one other thing about a special category of accidents, and that's construction site accidents. Almost by definition, the workforce in the construction site is mobile. And what that means, if you come to me 1 year after the construction site accident, you can guarantee that I will be unable to trace the witnesses. Most of these witnesses, in my experience, are long gone. So unless you get in touch with a lawyer at the beginning, you're really putting yourself at a severe disadvantage. One of the great mantras of our practice is, it's not what happened to you, it's what you can prove. You've got to give us a chance by getting the witness details, their names, their emails, their mobile numbers, so that we can take statements from them and be prepared to prove your case if necessary. And the critical legal question, again, this is maybe not all that well understood, is who had control of the workplace at the time of the accident? So if the scaffolding folds up and someone has a fall, and these accidents can be very serious, you need to know who the scaffolding company was, who was doing the inspection of the scaffolding, who was responsible for the defective scaffolding. A lot of the people come to me and they say, oh, well, we've got no rights because we're treated as self-employed. And it's notorious that everyone in the construction industry is self-employed. They're self-employed for tax reasons, and that's a legitimate way to proceed. But that doesn't mean that you don't have rights in the event of a construction site accident. Because again, it goes back to the critical question, who has control of the particular aspect of the work which you are doing which has caused the accident? But I say again, particularly for construction site accidents, time is not on your side. We are on your side, and get in touch with us as soon as possible. This brief video has really only scratched the surface. I've written a book called the Scotland Accident and Injury Advice Book, How to Avoid the Mistakes That Can Ruin Your Personal Injury Claim. It's available on Amazon. If you want a free hard copy, contact us and we will send one to you. Alternatively, we can send you a downloadable PDF, all free of charge. Just complete the online inquiry form. We're ready to listen and we're ready to help.